Thank you, Madam Chair. Good afternoon, Senator Valentino, Representative Cruz is not with us right now. Members of the Judiciary Committee, my name is David Burns, and I represent Senate District Number 29, which is comprised of all of Washington County and 11 communities in Hancock and Oscar. I stand before you today to present a committee amendment to replace the original draft of language of LD 1428, an act to protect religious freedom. This amendment creates a new chapter also, just to avoid any confusion, which is entitled Preservation of Religious Freedom. As you know, this bill was carried over to this session prior to any public hearing at my request, so that I could address concerns that several people have raised on the original language. I believe I've addressed most of those in this amendment. I want to thank specifically the chairs, you as a committee, and the analysts for your patience and cooperation. Let me start by explaining exactly what LD 1428 aims to do. LD 1428 requires that any governmental action infringing upon a person's free exercise of religion must be essential to further a compelling governmental interest and accomplished in the least restrictive way possible. In short, this means that the state must have a strong justification before it can infringe on religious liberty. Or, as President Bill Clinton explained in 1993 when he signed similar legislation, and I quote, "This law basically says that the government should be held to a very high level of proof before it interferes with someone's free exercise of religion," unquote. LD 1428 is that simple. It merely requires the government to thoughtfully weigh its own interest against the religious liberty interest of its citizens, a requirement placed on the government whenever it deals with fundamental rights such as speech, press, and as you will see, a requirement that government adhere to when dealing with religious liberty issues in 1990. Before I explain that, however, let me be clear. LD 1428 does not create any new rights. It does not, as some may suggest, make religious liberty a trump card against all government actions. It does not guarantee religious claimants victory in conflicts against government action. And it does not implement any unknown, previously untested standard for government action in the area of religious liberty. Why then is the bill needed? To answer that question, we must first understand the history behind LD 1428. As I'm sure that you are aware, religious liberty is considered one of America's most cherished rights. The search for such liberty not only brought countless people to these shores, but its preeminent place in the Bill of Rights caused religious liberty to be known as our, quote, first freedom. But in 1990, something happened to the first freedom. Something so egregious that groups who had rarely agreed on anything, such as the People for the American Way, Southern Baptist Convention, American Civil Liberties Union, and the American Muslim Council, would eventually band together to respond. In 1990, the U.S. Supreme Court unraveled decades of religious exercise case law and handed down its decision in a case, Employment Division v. Smith. In this decision, the court narrowly decided that government action infringing upon religious exercise did not have to have strong justification, as it had been a requirement for decades prior to Smith. Instead, the Smith court said government action could infringe upon religious liberty as long as that action was religiously neutral and could be applied generally to all people. Why though is that a problem? It's a problem because many neutral, generally applicable laws may still incidentally infringe upon free religious exercise. For example, a religiously neutral, generally applicable law forbidding alcohol consumption by minors could prevent Catholic minors from taking sacramental wine in a communion service. Prior to Smith, such minors could receive an exemption from that general prohibition. Under the Smith rule, these minors could be barred from fundamental religious practices. Thus, the Smith decision severely limited the free exercise of religion, gave less protection to religious liberty than other fundamental rights received, and, as Harvard Law Review put it at that time, and I quote, "It gutted the free exercise clause by distorting prior rulings, a process indicating the hostility to precedent that imperils the complete spectrum of constitutional liberties," unquote. The court's judgment in Smith caused a fiercely negative reaction from groups of all points across the political spectrum, including those previously mentioned. For example, in written testimony before the Senate Judiciary Committee in 1992, the then president of the ACLU, Nadine Strossen, strongly criticized the Smith decision. She said that in Smith, the court essentially, and I quote her, wrote the First Amendment's guarantees of free exercise of religion out of the Constitution, unquote. As observers predicted, this writing out, in quotes, of free religious exercise had severe consequences. One example can be found in the Yang versus Sterner case, a case from Rhode Island that illustrates the devastating impact of the decision of Employment Division v. Smith. 3 years before Smith, the 23-year-old son of Yo Yang and Ia Ku Yang, who were immigrants from Laos and members of the Hmong community, died after a seizure in his sleep. The Yangs sincerely held religious beliefs, forbade mutilation of the body through autopsies, but the medical examiner performed an autopsy on their son anyway, adding additional emotional devastation to the already heart-wrenching experience of losing a child. Subsequently, the Yangs filed a lawsuit, and in a decision issued before the Smith case was decided, the Federal District Court of Rhode Island ruled in favor of the Yangs, saying that the medical examiner had violated the Yangs' religious liberty by performing an autopsy on their son. The Rhode Island court then scheduled a hearing for damages. Before this hearing could take place, however, the U.S. Supreme Court handed down the Smith decision. Heeding Smith, the Rhode Island court had no choice but to withdraw its earlier decision and dismiss the case. In his opinion during the damages hearing, Rhode Island District Judge Raymond Pettine expressed deep regret over the reversal of his earlier decisions, saying that he had, quote, the deepest sympathy for the Yanks, but he noted that the Smith decision required upholding generally applicable laws, such as Rhode Island's autopsy law, despite the fact, and again I quote him, profoundly impaired the Yanks' religious freedom, unquote. Interestingly, Rhode Island was one of the first states to adopt their own religious liberty bill in the aftermath of the Smith. The Yang case was not the only example of Smith's damage to religious liberty, however. After 1990, governments throughout the United States also subjected members of the Jewish faith to autopsies despite their religious objections, zoned churches out of commercial areas, and in one case, forced a religious shelter for the homeless to close because it could not afford an elevator. In fact, according to President Bill Clinton in 1993, he said, and I quote, more than 50 cases have been decided against individuals making religious claims against the government action since the Smith case was handed down, unquote. In light of such injustices, a large, diverse coalition of more than 50 groups, including the ACLU, lobbied Congress to correct the Smith decision. In 1993, these groups were successful when Congress passed and President Bill Clinton signed the Religious Freedom Restoration Act. This law, which has the same primary purpose as LD 1428, restored the pre-Smith requirement of government to have a compelling interest served through the least restrictive means before it can infringe upon religious liberty. For a few years, the Religious Freedom Restoration Act served to restore proper balance between government interest and the free exercise of religion. But in 1997, another Supreme Court case dealt a blow to religious liberty, at least on the level of state level. In the city of Bourne v. Flores, the court ruled that while the Religious Freedom Restoration Act could apply to federal government, Congress did not have the power to levy it against the states. Consequently, adequate protection for the free exercise of religion had to be settled by each state. Indeed, 18 states, including Connecticut, Pennsylvania, and as mentioned previously, Rhode Island, have passed their own versions of the Religious Freedom Restoration Act in order to correct the Smith decision, ensure that their respective governments have strong justification before infringing upon religious liberty. LD 1428 would be Maine's version of the Religious Freedom Restoration Act. It would, in the same vein as the 18 other states, protect religious liberty of Maine citizens from unjustified government intrusion. Without it, the specter of Smith hovers over Maine and leaves the First Amendment guarantee of free religious exercise vulnerable to improper interference. What objections might critics raise then about LD 1428's passage? Please allow me to respond to at least 4 potential criticisms of this bill. First, some opponents may say that LD 1428 is unnecessary. You may hear critics say, even today, say that Mainers already have the First Amendment in the Constitution, Maine Constitution, to safeguard the religious liberty. But the history behind LD 1428 shows Mainers no longer have the same level of protection that were guaranteed before the Smith decision. Indeed, without LD 1428, state action has the potential to easily and with little justification infringe upon the First Amendment guarantee of free religious exercise. Furthermore, while Maine's state constitution also guarantees religious liberty, the history surrounding the Smith case demonstrates that without sufficient protection for this right, citizens are never more than one judicial opinion away from losing their religious freedom. Secondly, some opponents may suggest that the passage of LD 1428 will result in an explosion of litigation. But this fear is unfounded. Studies have shown that many states have seen very little litigation under their own